This is a short summary of a judgment handed down today in the case of KE Entertainments Limited against the Commissioners of Her Majesty's Revenue and Customs, HMRC, represented by the Advocate General for Scotland. The case is about the payment of VAT on fees charged for playing bingo. KE Entertainments Limited operates a number of bingo clubs in Scotland. Customers who want to play bingo at one of its clubs pay a fee, in return for which they get the right to play games of bingo, forming a session lasting a few hours. Cash prizes are paid to those who win games. Value-added tax, or VAT, is a tax charged on the supply of goods or services. Usually, it's charged on the full price paid by the customer. But in the case of commercial gambling, VAT is payable only on the amount of money kept by the organizer or promoter of the gambling, after deducting money paid out by the promoter as winnings. The dispute in this case follows a change in guidance published by HMRC about how bingo promoters should calculate this taxable amount. Until 2007, the guidance said that bingo promoters should calculate the VAT separately for each game of bingo. Then, in February 2007, HMRC issued what it called a business brief, advising that VAT should be calculated per session rather than per game. The session basis is more favourable to promoters than the game basis of calculation, because it tends to produce a lower amount of tax to pay. Until the business brief was issued, KE Entertainments, the taxpayer in this case, had accounted for VAT to HMRC on a per game basis. After seeing the business brief, the taxpayer switched to using the session basis of calculation. It also claimed a refund of the extra VAT that it had paid as a result of previously using the game-by-game method. The difficulty facing the taxpayer was a statutory time limit on claims for repayment of VAT, imposed by Section 80 of the Value Added Tax Act 1994. This time limit applies to any claim for repayment of an amount paid that was not, quote, VAT due to HMRC. At the relevant time, the time limit was 3 years. HMRC refunded the extra VAT which the taxpayer had paid in the previous 3 years. The question raised in this case was whether the taxpayer could also recover VAT paid in earlier years, going all the way back to 1996. To escape the 3-year time limit, the taxpayer had to argue that all the tax paid in those years, calculated on a game basis, was VAT due to HMRC. But if that was right, and all the tax paid was due to HMRC, it was not obvious why the taxpayer should be entitled to any tax refund. The taxpayer's argument was that the game method and the session method were both valid ways of calculating the VAT due. So when it had used the game method, the taxpayer was paying VAT due. However, it argued that when the guidance changed, it was invited to adjust its past VAT returns by relying on rules which allow adjustments to be made where the price payable for goods or services is reduced after the goods or services have been supplied. The taxpayer argued that the change to the session basis of calculation involved such a reduction in price. There is no time limit for making this type of adjustment. The taxpayer's argument was accepted by the tax tribunals, but was rejected by the Court of Session in Scotland. On its further appeal, the Supreme Court has unanimously dismissed the taxpayer's appeal. In our view, the taxpayer's argument did not get off the ground because there was only ever one correct method of calculating VAT, and that was the session-by-session method. It was an agreed fact that in return for the fee paid, a customer got the right to participate in a session of bingo. Customers could not buy separate tickets to play individual bingo games. In these circumstances, the correct way of calculating the VAT was on the basis of a session, as HMRC advised in the business brief. It follows that the extra amounts that the taxpayer had paid as a result of using the per game method were not VAT due to HMRC. That meant that the taxpayer was entitled to a refund, but also that the refund was subject to the 3-year time limit. This was a complete answer to the appeal, but the court also found further flaws in the taxpayer's argument. One was that there had not been a reduction in price after the supply had taken place, as happens, for example, if a customer becomes entitled to a rebate. In this case, no money had actually become repayable to customers. All that happened was that the method used to calculate the taxable amount changed. This does not come within the rules permitting adjustments to be made without any time limit. In addition, the HMRC business brief could not reasonably be read in the way the taxpayer sought to read it, as inviting bingo promoters to make this type of adjustment to their VAT returns. The business brief invited bingo promoters who found that they had incorrectly calculated VAT on a game-by-game basis to make a claim for repayment. But that could only reasonably be understood as a claim to recover amounts paid that were not VAT due to HMRC, so that the claim was subject to the 3-year time limit. For these reasons, explained in much more detail in the judgment, the taxpayer's appeal failed.